So I was asked to do a presentation on legal issues that would be of interest to grandparents. Not being a grandparent myself, I have to kind of guess at that. So what I'm going to talk a lot about is what I've come across in my practice, and that is grandparents' access to grandchildren when there's perhaps a divorce or some sort of fracture in the relationship between the parents and their grandchild. So just a little bit of background, I've been an attorney since 2001. I've been practicing in St. Elderwerks since June of 2006. We're a general practice law firm downtown Crystal Lake. We've got 10 attorneys there, so. Are you having a hard time hearing me? Is this better? Okay. Well, you missed my commercial then. So, in a nutshell, I've been practicing since 2001, downtown Crystal Lake at St. Elderwerks and Saladin. And again, I was asked to do a presentation on grandparent legal issues that grandparents might be interested in. And so I had to kind of scratch my head and think back over my years of practice and came up with some things that I hope you will find interesting. And if there's some sort of issue you have or wondering about at the end of my presentation, I could certainly happy to answer questions to the extent of my ability to do so. First, I have to figure out how to advance the slide. Okay, so the first topic I'm going to talk about are grandparents' rights under the IMDMA. And what that's short for is the Illinois Marriage and Dissolution of Marriage Act. Because in my practice, this is where folks have had issues when there's a divorce, their children experience a divorce, and that impacts their ability to have access to their grandchildren. So the first question is, what are my rights in this situation? And I'm going to go through the history of your rights under Illinois law and to a certain extent U.S. law because it impacts. But I'm going to tell you up front that unfortunately your rights are fairly limited. I will end up explaining them to you. But just by way of background, if you experience a divorce of a child that impacts your grandchild and your access to your grandchild, typically the way you're going to get access to your grandchild is through their parents' visitation time. So that's the most common way of getting access to your child is that, to your grandchild is you obviously still have a relationship with your child and take advantage of their parenting time to spend time with your grandchildren. But if for some reason, and there are numerous circumstances where you might not have access to your grandchildren through your children. So, for instance, if you have a child who chooses not to exercise parenting time and things like that, or perhaps I've seen situations where a child is incarcerated or maybe they're having some mental health issues, and so the grandparent is cut off from the grandchild in that situation. So when you look at the circumstances of a grandparent trying to get access to their grandchild through the court system, the first thing you have to look at is what kind of authority does a judge have to give you access to your grandchildren? Authority in general that a judge has comes from two ways. One is either through previous case law. So there's what we call precedent saying that the judge can award grandparenting time through previous case law, or there is a statute, an Illinois law that provides for that. So the judge has to have one or the other to even address the issue. So in the state of Illinois prior to 1982, there were no statutes on the books, no laws on the books that provided grandparenting time. So and this is where I'm just going to give you a little bit of the history in the state of Illinois. In 1982, the first law was passed that allowed a judge to provide for grandparenting time in a court scenario. In that case, it was limited to a situation where a parent had died, because remember, the primary way that a court is going to expect you to get access to your grandchildren is through your child. But in this case, they said that if your child had passed away, then you could petition the court directly for grandparenting time. And then in 1985, that law was expanded, and we had provisions put in place that prevented cutting off a grandparent's access from their grandchildren in the circumstances where perhaps a child has passed away and then the other parent who survives remarries and that spouse adopts the child. So they protected the grandparents, saying, okay, even if the spouse remarries and the new spouse adopts the child, you can't cut off the grandparents from seeing the children. And then so I'm referring to this as grandparent visitation or grandparenting time. So in 1998, they expanded the law to include step-parents, who you can imagine if a step-parent is helping to raise a child and there's a divorce, that it might be beneficial for the child and for the step-parent to have visitation after that. So that was a non-parental visitation provision that was added to the statute in 1998. So that represented an expansion of non-parental visitation, which is the category in which grandparent visiting time is considered. So in June of 2000, you were pretty much in a position where you could go to court and ask the court for grandparenting time. In June of 2000, there was a case from the state of Washington that involved a grandparent seeking visitation with a grandchild and was awarded visitation with a grandchild. And that award was appealed to the United States Supreme Court. And that's the case of Troxel versus Granville. So when that case was appealed up to the United States Supreme Court, the United States Supreme Court said that that Washington statute was unconstitutional. And in a nutshell, their position, the reasoning was that the court was substituting its own judgment for the judgment of a competent parent. And if a competent parent says that a grandparent should be cut off, then it's not the court's place to interfere with that relationship. In essence, they said that a parent's right to parent, they call it care, custody, and control, to have care, custody, and control over their child was a constitutional right. You know, they put it up there with the level of freedom of speech, the right to parent your children. And so they said that it's very, very high bar for the state to be okay in interfering with that relationship. So they reversed the Washington state case. Now, at that time, Illinois had their statute in place, and the facts in that case were very specific to the circumstances of that Washington case. So it was not considered that Supreme Court case overruled every grandparenting visitation statute in the country. However, it was quickly tested in the state of Illinois. So in this case, even though the Illinois statute was not as broad as the Washington statute, the Illinois Supreme Court stated that the Illinois statute was unconstitutional. And you can I put a quote from the ruling here where you can see that they're clearly relying on the U.S. Supreme Court's decision in Troxel. The crux of it says, the facts of this case do not warrant the state's interference with parents' joint decision regarding who may have visitation privileges with their children. To allow such an interference would unconstitutionally infringe on the parents' well-established fundamental liberty. So that's that tie to the case of Troxel, where they say that a parent's fundamental liberty is to parent their child and to determine whether grandchildren and any other people for that matter have access to their children. So in Illinois, we have recently had a complete rewrite of the Illinois Marriage and Dissolution of Marriage Act as it pertains to parenting time with the children and issues related to the children. So for parents, we no longer have visitation awards. So, if you're familiar with the divorce process, you have to divide up the children's time, obviously, because you're not going to do it for both parents all the time anymore. So now in Illinois, we no longer have custody. We have allocation of decision-making authority, and we have allocation of parenting time. So that's for parents. They separate out non-parental access to the children and label that visitation. So there is, in this new statute, it does make provisions for grandparents to petition the court for access to their grandchildren. However, you'll see when I go through the language that it very much follows the U.S. Supreme Court ruling in Troxel in the extent of its limitations on the court. So as I said before, grandparent visitation falls under the category of non-parental visitation, and that includes not only grandparents, but it includes great-grandparents, siblings, so if they're half-siblings, step-siblings, so that all kind of goes into the same category with grandparent parenting time. So the new statute does allow grandparents to bring an action for visitation, and even if there's no other case pending, like a divorce, the statute allows a grandparent to bring a petition. However, it's very restrictive in the circumstances where you can do that. So the new statute takes into account the U.S. and Illinois Supreme Court rulings and imposes restrictions. I think I probably had one slide here because I think I kind of did this backwards. So as a threshold matter, to even think about doing a petition for grandparent visitation, you're going to have to find yourself in one of these 5 categories. So either your child is deceased or missing for at least 90 days, the parent is incompetent, for whatever reason. That could be by reason of mental health issues, by reason of substance abuse, but there has to be a legal finding of incompetence. A parent has been incarcerated in jail or prison for a period in excess of 90 days. And keep in mind, these are or, so you just have to fall into one of these categories. There are proceedings pending addressing or involving custody. So, for instance, a divorce or a parentage action. If your child has had a child with somebody that they're not married to, they call that parentage proceedings. And at least one of the parents is objecting to visitation. Or finally, the child is born to parents who are not married, and the parents are not living together, but parentage has been established by a court. So that's, in fact, I think the least restrictive. If you have a grandchild and your child has had that grandchild outside of marriage, all the court requires is that the parentage has been officially established by a court. So if you find yourself in one of those 5 categories, then we move on to finally, when you can file a petition, what the criteria are for the judge. So in your petition, you have to allege that there has been an unreasonable denial of visitation by a parent to you, the grandparent. So that's the unreasonable. And that's really, it's very hard for a judge to say that a parent's decision is unreasonable. So it makes it very strict and limiting because in effect they would have to be substituting their opinion for the child's opinion. So it's a high legal bar to reach that. But if you can convince a judge that has been unreasonable restrictions and that denial of your access to your grandchild has caused the child undue mental, physical, and emotional harm, then the judge has a basis to grant you grandparenting time. And the thing I want to emphasize here is that by saying not only is it unreasonable, but that it's caused the child a specific harm, this puts you into the realm of needing to get expert witnesses. So it's a high burden because, and I've seen this unfortunately happen where a grandparent has gone to court and their attorney just put them on to testify and maybe other family members on to testify. And they testify to, the child's crying, the child wants to see me, maybe even observing what they believe to be distress in the child, and it's simply not enough. The judge needs to have expert witness testimony, in my opinion, to be able to rule in your favor in this kind of a petition. So that it makes it a very high burden and also puts a high financial cost associated with it. As if, hiring an attorney and going to court isn't expensive enough, because if any of you have been involved in that situation, you know that it is, but they've sort of added an extra layer of restriction and expense if you do find yourself in the area where you need to go to court for grandparent visitation. So another thing that the judge must presume, and again, in the legal world, that means that you've got a really high wall to climb to get over that presumption if you're trying to rebut the presumption, to show that the presumption doesn't apply in your case. So the judge has to presume that a fit parent's actions and decisions regarding visitation are not harmful. So again, this directly to that Supreme Court case in Troxel where the U.S. Supreme Court says, hey, unless you're saying this is an unfit parent, and you have to prove it's an unfit parent, then their decisions are going to stand. So if you make it past all those hurdles, then the court will analyze a bunch of different factors and determine if the grandparenting visitation is in the best interest of the children, what it should look like. And they will take into account various factors. And if you've made it through all this, you've made it a long way. And I was at least happy to see that the judge can take into account the good faith of the parties. So if it's the parent that somebody, is trying to keep a grandparent away from a grandchild, out of spite, maybe for a bad divorce or whatever, that the judge can take that into consideration if you make it this far in the process. Also, factors that you would expect would be typical, let's look at the mental health of the child. Is there going to be health harm? Should it be once a week, once a month, every other weekend? So those are the type of things that the judge will get into when you reach, when you get this far in the process. So if you've gotten this far in the process, what could potentially cut off your visitation as if there's an adoption. So again, in this situation, if your child has passed away, the former spouse of your child remarries and that new spouse adopts your children, it automatically terminates your grandparents' visitation. However, the statute gives you standing to go in there and get it reestablished again. But unfortunately, you would have to go through all the same hoops that you went through before. So that's kind of the background on what grandparent visitation looks like in divorce. And from a perspective of a grandparent, I want to touch base a little on divorces and how divorces unfold. If you ever find yourself in a situation where your child is contemplating divorce or going through divorce, or maybe even your grandchild is contemplating divorce, going through divorce, I have to tell you that I've been, I do family law in addition to doing estate planning and elder law, and I was a family law litigator for many years. And I can tell you that if any child or grandchild comes to you with advice, the best thing you can tell them is work it out outside the court. Because first of all, the court is they're going to be hemorrhaging money in the court system. And it's by nature, it's an adversarial process, right? It creates winners and losers, guilty, not guilty. That's good for crime, that's good for businesses where you need to have things in black and white, and clarity is good. But that adversarial situation does not work well for families. Because ideally we want everybody to be in the best situation they can be in, coming out at the other end of the divorce. So as a grandparent, probably the most preventative thing that you can do if you're confronted with this situation is to try to help counsel so that, and maybe you're talking about great-grandchildren at this point, help counsel them to go through the process without getting to the point where people are so bitter at the end that they're denying the other family access to the children, even though we all know that the more family that a child has in their life, that love them, the better off they are. But when you start getting into the legal system, you can see that there are all kinds of competing factors that compete with the best interests of the child, particularly when we're talking about parents having constitutional liberties to make decisions for their children. So that sort of little stick figure thing there is exactly what you don't want to see happen to your children or your grandchildren in divorce. I think people typically think that they're fighting when they get divorced, and they're going to go to court, and they're going to be heard. The judge is going to hear their side of the story, they're going to be vindicated. And I can tell you that none of that ever happens in court. It's just they give up control over their lives and their children's lives. Not to mention that it's outrageously expensive. So I stopped doing litigated divorces several years ago because I just felt like I couldn't be a part of it anymore, and there's so many other options. So I'm just going to take some time here to educate you a little bit about other divorce options so that you can counsel your children and grandchildren if they ever find themselves in that situation. So if you go into a law firm anywhere in McHenry County or elsewhere, really, and you express an interest in getting divorced, probably the first thing that you're going to hear is, okay, well, we have to file a petition for dissolution. We'll serve the spouse with a summons, and then we're going to do discovery, which is a technical term for exchanging information, and off you go. And they won't be offered options, and I'm here to tell you they have options. On one end of the spectrum, you may have seen the War of the Roses, right? Most of us don't have the money to finance that type of litigation, but really only the attorneys win in that situation. So the other options, and I can speak for myself, the other options I offer people are what I call an uncontested divorce. So if they can sit down and decide who's going to pay what bills, who's going to get what asset, what a parenting schedule is going to look like in the best interest of their kids, then I offer them a flat fee divorce. I call that the kitchen table divorce. I'm not sure if I have a slide on that one or not. Oh, yeah, see, I'm going backwards. So I do many of these. And not everybody can get a divorce through a kitchen table divorce. I recognize that. But if you can, obviously there's a huge benefit of, they're going to know the cost of their divorce up front. And they're going to get through the process smoothly because I'm going to help them through it. And I can help them with, well, we don't want to sell the house right now. We want to wait till the kids are out of high school. What does that look like? Can you do that? Things like that. So I can help them with that. So I've had a lot of luck with this, and the flat fee is a powerful incentive for people not to fight because they really like the idea of limiting their costs. Another option is collaborative divorce. Collaborative law, the Uniform Collaborative Law Act was just passed in Illinois this year. And what a collaborative divorce looks like is you have the core collaborative team, which is the divorcing couple and their attorneys. And we all sign a participation agreement at the beginning saying we're going to resolve everything out of court. If somebody goes to court before we have an agreement, which, involves agreements with grandparents, you can put those in there when you're not limiting yourself to what the court normally does. So we're going to work everything out of court, and we're only going to file when we're ready to finalize. So, as you can imagine, not everybody can do an uncontested divorce, and collaborative law is a way to deal with all of that conflict outside of court. So, if we have a disagreement over what's in the best interest of the child, we bring in a neutral child expert. So you're paying one child expert to give the parties advice, and you know that it's neutral advice, whereas in the court system you're going to get two dueling experts and they're going to basically cancel each other out. So we can bring that in. We can bring divorce coaches in who are mental health professionals, and their only role in the process is to help people manage their emotions during the divorce process so that they can make good decisions for their children, encourage access of grandparents to the children. So there are all kinds of, we can bring in financial experts. So there's all kinds of resources we bring into the process in collaborative law, and manage those emotions. And dealing with those emotions during the collaborative law process is what helps keep people out of court on the other end. Because when you go to court, grandparent visitation might not even be addressed. It might come up later. And so you resolve these underlying emotional issues that the court process does not address. And so you end up with an agreement that everybody can live with, and that really is in the best interest of the children, and it's a lot less expensive. And most importantly, I think people don't realize how much control they give up when they go to court. Because ultimately, complete strangers can decide, whether you as grandparents get access to your grandchildren, and what their schedule is going to be like and all that. And that really, whenever possible, should be reserved by the parents. So, having covered the grandparents' rights to access to the children and ideas to counsel your children and grandchildren when, if they're confronted with the possibility of divorce, I just want to touch on a couple of other things that you might be thinking about or should think about in your role as a grandparent. Take a look at your estate plan. Do you have provisions in there for your grandchildren? Was did you make the will when they were like 2 years old, and now maybe they're in college, or they're responsible professionals. So take a look at those provisions and see if you want to leave something to your grandchildren. If you've done it, is it still the way that does it still match up with their circumstances and your circumstances today? So just quickly, and this isn't a presentation on estate planning, but for those of you who may not have an estate plan or not sure, a lot of people, you say estate planning, you assume that it involves great wealth. And really, everybody should have an estate plan, once they turn 18 years old, basic powers of attorney and wills. So what that does is, at a minimum, for instance, if you have a grandchild that's gone off to college, what if they get into a car accident? And your children might assume they still have, that they can call up the hospital and talk about their medical condition. And that's just not the case anymore. Once they turn 18, if the parent doesn't have a power of attorney, then the medical information is confidential. So that's something to think about. Do you have an estate plan? Do your children have estate plans? Particularly if their children and your grandchildren are minors, you want to make sure that they have a will that names a guardian, so that it's not binding on court who the parent chose as a guardian, but unless there's a good reason not to use the guardian named in the will, the court's going to follow that. And if there's no guidance to the court, then it's just who presents themselves at the time. So I'm just repeating myself a little bit here. So the estate plan will help you avoid probate as well. A lot of people think that if you have a will that prevents you from going to probate. That's not the case. So it's a good way to make sure that your children and grandchildren, whoever, are not fighting in court, is to make sure you get that will in place at a minimum. But you can also do living trusts that give you more control over how and when your heirs will inherit. I'm happy to talk about that another time. It's not really my topic, but I just wanted to point out that as grandparents that you still need to think of not only your estate plans, but your children's and what's going on with your grandchildren as well. So I do have copies of my presentation down here. If you want to take one with you, you're welcome to, as well as my business cards. But I'd be happy to answer any questions on topics that I haven't covered if anybody has any questions. No, doesn't look like no questions. Really, free legal advice? Nobody's taking? Okay, well, thanks for taking the time to come see my presentation. And like I said, my card's down there and a copy of the presentation is there.